Please be seated.
The proceedings are called to order. Would the registrar introduce the matter coming for the trial chamber this morning, please?
Thank you, Mr. President. Trial Chamber 2 of the International Criminal Tribunal for Rwanda, composed of Judge William H. Sekule presiding, Judge Solomi Balungi Bosa, and Judge Impirani Rajanson, is now sitting in open session today, Thursday, the 20th of December, 2012, for the delivery of the judgment in the matter of the prosecutor versus Augustine Ngirabatware, case number ICTR 99-54-T. Thank you.
Thank you, Mr. Hamato. For the registry, may we have the appearance of the parties, starting with the prosecution, please, if you may.
Good morning, Your Honors, the prosecutor in person, and with me are the Chief of Prosecutions, Richard Karegeza, Wallace Kapaya, Senior Trial Attorney, Rashid, Trial Attorney, Iskander Ismail, Assistant Trial Attorney, and Faria Rekas, Case Manager. As it pleases Your Honors.
Thank you, Mr. Prosecutor and the other counsel. May we also have the appearance for the defense, please?
Good morning, Mr. President. Good morning, Your Honor. Milen Dimitri, lead counsel for Mr. Ngirabatware, accompanied this morning by our co-counsel, Mr. Claver Sindaigaya, our legal assistants, Dr. Deogracias Sebourizé, and Maître Philippe Plourde. Unfortunately, the other team members, Ms. Anne-Gaëlle Denier, Greg Shankman, and Juvenal Bahagahorani, couldn't be here this morning.
Thank you, Leonard Counsel. Judgment. Introduction. The Chamber will now read out a summary of the judgment in this case, which will address the central findings in the written judgment. In doing so, the Chamber emphasizes that only the written judgment is authoritative. It will be made available as soon as possible after the completion of the editorial process. The accused in this case, Augustine Ngirabatware. The accused in this case is Augustine Ngirabatware. Ngirabatware was born in 1957 in Nyamnyumba Commune, Gisenyi Prefecture. He obtained a PhD in economics science in 1986, after which he worked in various ministries in the Rwandan government. Ngirabatware served as the Minister of Planning from 1990 through July 1994. He was also a member of the National Committee of the MRND Party, of the Prefecture Committee of the MRND Party in Gisenyi, and of the Technical Committee of the Nyamnyumba Commune. The prosecution had charged Ngirabatware with conspiracy to commit genocide. Genocide, alternatively complicit genocide, direct and public incitement to commit genocide, and extermination, and rape as a crime against humanity. During closing argument, the prosecution dropped the charge of conspiracy to commit genocide and maintained the other 5 charges. The prosecution alleges that Ngirabatware bears direct responsibility for having planned, instigated, ordered, aided, and abetted, and committed these crimes, including through a joint criminal enterprise in both the basic and extended forms. The defense disputes all charges and challenges the credibility of the prosecution evidence. In addition, the defense has presented an alibi for 6 to 12 April 1994, 23 April to 23 May 1994, and the 23 June to 3 July 1994. The defense submits that Ngirabatware should be acquitted of all the charges against him. The trial in this case commenced on the 23rd September 2009. The chamber heard the evidence of 62 witnesses and admitted 310 exhibits into evidence. The prosecution presented 27 witnesses, 7 of whom testified in rebuttal, and tendered 93 exhibits into evidence. The defense called 35 witnesses, including the accused, and tendered 216 exhibits into evidence. The chamber has also admitted into evidence the report of the chamber's site visit to the Republic of Rwanda, which was undertaken over 5 days in May 2012. Throughout the proceedings, the parties filed a total of 147 written motions, 47 from the prosecution and 100 from the defense. The chamber heard closing arguments on 23rd, 24th, and 25th July 2012. It now renders judgment in this case. Factual and legal findings. Influence. Both the prosecution and the defense adduced extensive evidence concerning Ngirabatware's influence in and around Namnyumba commune in 1994. A number of prosecution witnesses described Ngirabatware as being tantamount to a god, in quotes, in the region, and Ngirabatware acknowledged that he was a figure of authority in Gisenyi Prefecture. Having considered the overwhelming evidence and taking into account Ngirabatware's various positions and the extent to which they were known around Namnyumba commune, the chamber has no doubt that Ngirabatware was an influential and well-known personality in Namnyumba commune and its surrounding areas throughout the relevant events in 1994. Election of Bagango. Election of Faustin Bagango. The indictment alleges that Ngirabatware wielded this influence to ensure the appointment of Faustin Bagango to the position of Bookmaster of Namnyumba in April 1994. The defense responds that Bagango was fairly elected through a secret ballot in 1993. Only one witness provided evidence that Bagango became bookmaster in 1994. Conversely, 11 witnesses stated or implied that Bagango attained this post at some point in 1993. This year is further supported by the documentary evidence. The chamber considers that Faustin Bagango became bookmaster of Namnyumba commune in 1993. 6 prosecution witnesses agreed that an election took place, and 9 prosecution witnesses testified that Bagango was either appointed by Ngirabatware or else was elected owing to the influence of Ngirabatware. The sheer number of witnesses testifying in a similar fashion raises the possibility that Ngirabatware either rigged the election or swayed the electorate to vote for Bagango. This possibility is strengthened considering the close association between Ngirabatware and Bagango. The chamber has noted, however, that none of these witnesses provided a first-hand account of the election, offering instead a mix of hearsay, rumor, speculation, and inference. In contrast, 6 defense witnesses testified to having participated directly in the election, and none of them described an unfair election or undue influence by Ngirabatware. The Chamber finds that the prosecution has not made out its case in relation to this allegation. Kanyabuhombo School. The prosecution alleged that at a meeting at a Kanyabuhombo School in early 1994, Ngirabatware told the audience to hunt for Tutsi and kill them, and distributed weapons at the school. Two prosecution witnesses provided credible, reliable, and mutually corroborative evidence about this meeting. Their accounts have not been undermined by the evidence presented by the defense. The Chamber finds that in early 1994, a few hundred people attended a meeting at Kanyabuhombo School, including Ngirabatware, Bookmaster Bagango, and Councillor Jean Simpunga. Bagango introduced the officials and asked for weapons to fight the Inkotanyi, in quotes. Ngirabatware then spoke for an hour, during which he commended Bagango's energy and the Interahamwe's strength, and claimed that only the MRND and CDR parties could safeguard Hutu interests by fighting the Tutsi, and told the crowd that he would be providing weapons. About an hour after the meeting ended, Bagango went to the Nyamunyumba commune office and distributed weapons to Interahamwe and Impunzamagambi leaders. In considering Ngirabatware's public address on this day, the Chamber has observed that both prosecution witnesses understood his speech to be intended to fan ethnic hatred between Hutus and Tutsis. The Chamber considers hate speech to be deplorable in any context, but particularly where ethnic tension already exists, and the speech is directed towards inflaming this tension even further. Nevertheless, the Chamber recalls that mobilizing hatred against an ethnic group is distinct from direct incitement to commit a violent act against that group. Hate speech may be preceded or accompanied direct incitement to commit genocide, but is not an offense under the Genocide Convention or under the ICTR statute. Accordingly, the Chamber does not find that Ngirabatware directly and publicly incited genocide through his speech at the Kanyabuhombo School. The prosecution has also not established beyond reasonable doubt that Ngirabatware distributed weapons at the meeting at the Kanyabuhombo School as alleged in the indictment, even though weapons were distributed later by Bagango at a different location. The prosecution has not established that the distributed weapons were used to kill or harm the Tutsi in Namunyumba commune. Because there is insufficient evidence to link this meeting with any subsequent killing or attacks, the Chamber finds that Ngirabatware has not been proven guilty of genocide or complicit in genocide in relation to the meeting at Kanyabuhombo School. Speeches at roadblock and creation of Interahamwe group. Speeches at the roadblock and creation of Interahamwe group. Two prosecution witnesses testified that after the death of CDR chairman Martin Buchana in February 1994, demonstration occurred in Namunyumba commune at which Ngirabatware was present and spoke to the assembled crowds. One prosecution witness described a speech at the electoral gas roadblock, and both witnesses discussed Ngirabatware's speech at the Chanika Gisa roadblock. These witnesses provided credible and reliable testimony that was not undermined by the defense evidence. Based on this testimony, the Chamber finds Judge Sekule dissenting that Ngirabatware went to Electrogas roadblock. Approximately 400 people were present, and Ngirabatware told them that one roadblock was not enough and that another needed to be established in order to prevent Tutsis from crossing it. Although this speech was made publicly and was intended for the public audience, the Chamber is unconvinced that the Ngirabatware's speech was sufficient direct to constitute incitement to commit genocide. The prosecution has also alleged that in early 1994, Ngirabatware created a group of Interahamwe militia and positioned them at Kitarako in order to capture and kill Tutsis who were fleeing to Zaire. The evidence establishes that the Kitarako roadblock was set up after 6 April 1994, but the Chamber has not found that the only reasonable inference is that it resulted from Ngirabatware's instruction at the Electrogas roadblock in February 1994. Nor is there evidence to substantiate the allegation that Tutsis were captured, killed at this location, or that Ngirabatware participated in creating a group of Interahamwe to be positioned there. This allegation has not been proven. In relation to Ngirabatware's speech at the Chanika-Gisa roadblock in February 1994, after Buchana's death, the Chamber finds as many as 150 to 200 people had been assembled there. Ngirabatware spoke to the crowd and told his audience to kill a Tutsi. Ngirabatware then gave 50,000 francs to one Honori Dayaminyeneshi to buy drinks and all traditional weapons. The Chamber has no doubt that Ngirabatware's speech to the crowd objectively and ambiguously called for genocide against the Tutsis, and that Ngirabatware's intended audience was the public. Accordingly, the Chamber finds beyond reasonable doubt that Ngirabatware committed direct and public incitement to commit genocide by virtue of his speech to the crowd gathered at the Chanika-Gisa roadblock. There is insufficient evidence, however, to establish beyond reasonable doubt that Ngirabatware's role at the Electrogas and Chanika-Gisa roadblocks contributed to any subsequent killings or attacks. Consequently, the Chamber finds that Ngirabatware has not been proven guilty of genocide or complicit in genocide in relation to his speeches and action at these roadblocks in February 1994. Meetings. Turning to March 1994, the prosecution alleged that Ngirabatware convened a meeting at his half-brother Chenge's house and another meeting at the MR&D Palace in Kisenyi. The prosecution brought no evidence to support these allegations. The Chamber therefore concludes that these allegations have not been proven. The prosecution further alleges that Ngirabatware convened MR&D party meetings in Namunyumba commune throughout March in 1994. The Chamber finds that Ngirabatware, Bagango, and Simpunga all spoke at meetings at the Katunda School in March 1994. Ngirabatware told the crowd that bad grain should be separated from the good grain, which was understood as calling for the separation of Tutsi from Hutus. This meeting, however, is not mentioned in the indictment, even though the prosecution was aware of it several years before filing the operative indictment. The Chamber recalls that the prosecution must know its case prior to trial, and cannot tailor its case against an accused person depending on how the evidence unfolds. Considering the absence of any mention of the Gatunda School meeting in the indictment or in any relevant pre-trial submissions by the prosecution, the Chamber has not considered the meeting at the Gatunda School as a basis for conviction. The Chamber also finds, based on the evidence, that Ngirabatware attended and spoke at a meeting at the Umganda Stadium at the beginning of 1994. Ngirabatware stated that the enemies of Rwanda were the Tutsi living outside the country who were collaborating with the Tutsis residing in Rwanda, those who were married to Tutsis, and Hutus who were collaborating with RPF. This meeting, however, was not pleaded in the indictment. The relevant paragraph of the indictment alleges meetings in Namnyumba commune, whereas Omganda Stadium was located in Rubavu commune. Nor does the prosecution rely on this meeting in support of its allegation about MRND meetings in March 1994. The Chamber, therefore, has not considered this meeting as a basis for conviction. Likewise, the Chamber has found that Ngirabatware, Bagango, Major Xavier Uwimana, and others attended a rally flag-raising ceremony at Kitarako in early April 1994 before President Habyarimana's plane was shot down. Ngirabatware spoke to around 600 to 800 Interahamwe and asked them to continue to man the roadblocks and carry out night patrols to avoid infiltration by the enemy. The vice chairman of the Interahamwe asked Ngirabatware how they could manage night patrols armed only with sticks. And Ngirabatware responded that he and Major Uwimana would find a solution to that problem. Ngirabatware also promised them at least one firearm so that they could shoot in the air to disperse the enemy. A few hours later, Major Uwimana drove to the Gisimbi Kotagirwa roadblock in a vehicle with cartons and boxes. Bagango arrived and stated that Uwimana brought the material that had been promised to the Interahamwe earlier that day at the Kitarako meeting. Bagango thanked Uwimana and asked him to express their thanks to Ngirabatware as well. 6 cartons of grenades and crates with firearms were distributed at the Gisimbi Kotagirwa roadblock. These weapons were subsequently used to kill the Tutsis. Because this event was not pleaded in the indictment, the Chamber has not considered it as a basis for conviction. The Chamber will now turn to events following the assassination of President Habyarimana on 6 April 1994. The Chamber will first discuss the details, the defense alibi, before addressing the prosecution allegation for this period. First, alibi. The defense relies upon alibi evidence that Ngirabatware was in Kigali in the days following this assassination, from 6 to 12 April 1994. In particular, the defense submits that Ngirabatware, his family, and others took refuge in the presidential guard camp on the nights of 6 and 7 April 1994, and that they were moved to the French embassy on the morning of 8 April 1994. The prosecution disputes this alibi and alleges that on the 7 and 8 April 1994, Ngirabatware was committing crimes in Namnyumba commune. The Chamber recalls that an accused does not bear the burden of proving his alibi beyond reasonable doubt, but must simply present evidence likely to raise a reasonable doubt in the prosecution case. The Chamber has considered the totality of the evidence with this principle in mind. Having done so, the Chamber considers that the defense witnesses who testified in support of the alibi for 7 April 1994 are not credible. Their evidence suffered from numerous inconsistencies and discrepancies, combined with the insufficient notice of alibi in this case. The Chamber considers that there is a high probability that this alibi was tailored to fit the prosecution case. The evidence, when viewed as a whole, does not raise the reasonable possibility that Ngirabatware was in Kigali on 7 April 1994. In relation to the alibi for 8 April 1994, the Chamber notes that the French embassy in Kigali sent telegrams on this day, which appear to indicate that Ngirabatware may have been present at the embassy. The Chamber finds that it is reasonably possibly true that Ngirabatware may have been at the French embassy around the early afternoon on 8 April 1994. Distribution of weapons, 7 April 1994. Two prosecution witnesses testified to having seen Ngirabatware in Namunyumba commune on separate occasions just prior to the attack on Safari Nyambwenga on 7 April 1994. The Chamber has found their evidence to be credible, reliable, and mutually corroborating. The Chamber has found the evidence to be credible, reliable, and mutually corroborating. The defense evidence has not raised doubt in this regard. The Chamber finds on 7 April 1994, Ngirabatware arrived at the Bruxelles roadblock in Namunyumba commune in the first of two vehicles. Ngirabatware asked that Bagango be located, and once Bagango arrived, Ngirabatware said that he brought weapons because he did not want to see any Tutsis alive in Brussels. Ngirabatware provided 10 machetes to Bagango, who in turn gave them to Councillor Jean Simpunga for further distribution. Simpunga distributed 9 of these machetes to roadblocks in the area and kept one for himself. Bagango said that the remaining machetes would be taken to other areas in the Namunyumba commune. Later that same day, Ngirabatware returned to the Brussels roadblock in the first of two vehicles. Many Interahamwes were present, including Juma. Ngirabatware chastised the Interahamwe for only pretending to work, and he charged that Safari was communicating with the Inyenzi, in quotes. Firearms and grenades were offloaded. Ngirabatware then drove to the nearby Kisimbi Kotagirwa roadblock, where he again summoned Bagango, who came immediately. Weapons were offloaded once more, and Ngirabatware explained that he brought the weapons because he did not want to see any Tutsi remaining in Namunyumba commune, and he ordered Bagango to work well. Ngirabatware also told Bagango that Safari needed to be located and killed. Shortly afterwards, Safari Nyamwenga, a Tutsi, was attacked and seriously injured by various Interahamwe. Juma was only one of the numerous Interahamwe who manned the notorious Kisimbi Kotagirwa roadblock and attacked Tutsi civilians starting on the 7th of April 1994. Prosecution and defense witnesses confirmed that Juma was joined in this action by many other Interahamwe, including Makuze and Felix Niyoriringiye. The indictment alleges that Ngirabatware is responsible for having committed genocide through a joint criminal enterprise. In relation to the weapons in relation to the weapons distribution on 7 April 1994, however, paragraph 16 of the indictment clearly charges Ngirabatware only with having instigated and aided and abetted genocide. This specification indicates that the prosecution did not charge Ngirabatware with any other model of liability for this distribution of weapons, including through a joint criminal enterprise. As a result, the Chamber has considered only whether Ngirabatware's words, action on this day, instigated, aided, and abetted genocide. The Chamber further finds that at least some of these weapons distributed by Ngirabatware on 7 April 1994 were used by the Interahamwe during the attacks and killings. Ngirabatware's words and action both prompted and encouraged the Interahamwe to kill and substantially contributed to the subsequent attacks and killings of Tutsis in Namunyumba commune. He knew that the Interahamwe who perpetrated these crimes possessed genocidal intent. The Chamber therefore finds beyond reasonable doubt that Ngirabatware instigated, aided, and abetted genocide through his words and action on 7 April 1994. The Chamber further observes the coordination between Ngirabatware, Bagango, and Simpunga as authority figures with Juma, Makuze, and Niyoringiye, who manned the Kisimbi-Kotagirwa roadblock together and singled out Tutsis for attack and killed them. Given these interactions and chains of events, the Chamber has no doubt that Ngirabatware and these other individuals possessed genocidal intent and that each significantly contributed to their shared goal of ridding Namunyumba commune of Tutsis. Based on the totality of the evidence in this case, the Chamber finds reasonable doubt that Ngirabatware participated in a joint criminal enterprise with Faustin Bagango, Jean Simpunga, Juma Makuza, Felix Niyoringiye. This joint criminal enterprise was in existence by 7 April 1994, and its members shared the common purpose of destroying in whole or in part the Tutsi ethnic group as such, and extermination of the Tutsi civilian population in Namunyumba commune. Killings in furtherance of prior agreements. The indictment alleges that in April 1994, Ngirabatware instigated the Interahamwe to seek out and exterminate Tutsi civilians in Kisenyi Prefecture in furtherance of agreement made at prior meetings in February and March 1994. The prosecution adduced no evidence of these prior agreements and instead dropped the allegations relating to them after the close of its case in chief. The prosecution also made no closing submissions on this allegation. The Chamber finds that the prosecution has not met its burden in establishing this allegation. Events at Alphonse Bananier's home. One prosecution witness testified that in the evening of 7 April 1994, she was taking refuge in Alphonse Bananier's home when Ngirabatware arrived, hid 2 boxes of weapons in the house, and subsequently gave them to Bagango. The Chamber considers her testimony to be generally credible and reliable. It was unaffected by defense witnesses. Based on her testimony, the Chamber finds that in the evening of 7 April, Ngirabatware and Bagango were present at Bananier's home. Nevertheless, this prosecution witness, in a prior statement to tribunal investigators, did not mention the presence of weapons at this event, as alleged by the prosecution. The Chamber considered this to be a material omission warranting appropriate caution. Under the circumstances, the Chamber does not consider her evidence sufficient to base a finding beyond reasonable doubt about the presence of weapons at Banani's home in the evening of 7 April 1994. A different prosecution witness testified that Ngirabatware was also present at Banani's home the following day, 8 April 1994, around 2 p.m. Although the Chamber finds this witness evidence to be credible and reliable, the Chamber has also found to be reasonably possible true that Ngirabatware may have been at the French embassy in Kigali around this time period. This raises reasonable doubt as to this event. Instruction to Interahamwe. The indictment alleged that around 7 April 1994, Ngirabatware instructed the members of the Interahamwe to remove all the dirt between their teeth and pull up all the weeds from the millet field. The prosecution has presented no evidence to substantiate this allegation. As such, it has not been proved. Killing of Mukarugambwa. The evidence established that around 8 April, Felix Niyoringie killed a woman named Mukarugambwa. Although Niyoringie was a member of the joint criminal enterprise with Ngirabatware, the indictment does not charge Ngirabatware with having committed this event. Instead, it alleges that Ngirabatware planned, instigated, ordered, and aided and abetted this killing through Ngirabatware's listing of Tutsis for extermination. Because the prosecution has not established that Ngirabatware participated in this listing of Tutsis for extermination, the Chamber does not find Ngirabatware guilty in relation to the killing of Mukarugambwa. Rape. Two prosecution witnesses testified that Juma and Makuze raped the Tutsi woman identified in paragraph 63 of the indictment. This was corroborated by a third prosecution witness. Based on their evidence, the Chamber has no doubt that Juma and Makuze abducted this Tutsi woman about 7 days after the president's death, took her to a nearby banana plantation, and raped her. 3 days later, Juma Makuze returned, took her back to a banana plantation, and raped her again. These rapes occurred within the context of a widespread, systematic attack directed against the civilian population on ethnic grounds, which was known to the perpetrators. The Chamber finds that this constitutes rape as a crime against humanity. As noted earlier, Juma and Makuze were members of the joint criminal enterprise with Ngirabatware. Although the common purpose was to destroy and exterminate Tutsis, the Chamber finds that it was a natural and foreseeable consequence that at least some of the members of the joint criminal enterprise would resort to rapes and sexual assaults. Ngirabatware was subjectively aware of this risk, and he willingly accepted it through his distribution of weapons in Namunyumba commune and encouragement of the Interahamwe to kill Tutsis. Accordingly, the Chamber finds reasonable doubt that Ngirabatware committed rape as a crime against humanity through the extended form of joint criminal enterprise liability. The prosecution further alleges that two Tutsi women identified in paragraph 61 and 62 of the indictment were also raped by the Interahamwe around April 1994. One prosecution witness testified that the victim alleged in paragraph 61 was raped, but the witness did not know when this occurred, nor did she provide further details. No witness testified that the victim alleged in paragraph 62 had been raped. The Chamber finds that the prosecution has not proven this allegation beyond reasonable doubt. Distribution of machetes mid-April 1994. The prosecution alleges that in mid-April 1994, Ngirabatware ordered Bagango to distribute machetes to attackers. In support of this allegation, the prosecution refers to the same evidence presented to establish the distribution of weapons on 7 April. The Chamber finds this allegation has not been proven. The killing of 10 Tutsis. The prosecution alleges that in mid-April 1994, Ngirabatware instigated, publicly incited the Interahamwe to kill 10 Tutsis, including a lady named Nyamunini. This allegation was supported by the hearsay evidence of a single prosecution witness. Other prosecution witnesses testified that this lady was killed before 1994. The Chamber finds that the prosecution has not met its burden in relation to this allegation. Meeting at Ngirabatware's parents' house. The prosecution further alleges that Ngirabatware convened 3 meetings at his parents' house in mid-April, late April, and late May. It further alleges that Ngirabatware brought grenades to the Interahamwe who convened at his parents' house in mid-April 1994. One prosecution witness testified about 2 meetings at this location that took place around early May and mid-May in 1994. In addition to the first alleged meeting, the witness testified that she did not see Ngirabatware there, but was able to hear him speaking. The witness provided no basis for her ability to identify Ngirabatware by his voice. Absent of corroborating evidence, the Chamber cannot conclude that Ngirabatware spoke and was present at this meeting. In relation to the second alleged meeting, this witness provided only hearsay evidence from an Interahamwe who described having participated in the attack on Nyamunini. This evidence lacked detail, corroboration. According to the Chamber, find that these allegations have not been proven beyond reasonable doubt. Second alibi and third alibi. The Chamber will now turn to the defense alibi for the period 23 April to 23 May. The defense submits that during this time period, Ngirabatware was not in Rwanda, but was instead traveling in or through Zaire, Cameroon, Gabon, Togo, Ivory Coast, Senegal, France, Swaziland, South Africa, Zambia, and Kenya. In addition to witnesses' testimony, the defense relies on documentary evidence, including the Ngirabatware's passport. The prosecution challenged the passport as containing forged stamp and the visa impressions, and it refers to the witnesses brought in rebuttal. The Chamber has significant reservation about the credibility and reliability of the evidence presented by the defense. There are numerous discrepancies and irregularities located throughout the passport. The defense witnesses did not offer credible testimony, and the defense failed to file a notice of alibi for this time period in contravention of the rules of procedure and evidence. By contrast, the prosecution presented credible and comparing rebuttal evidence challenging the defense alibi evidence. Having assessed the credibility of the alibi evidence as a whole, the Chamber finds that it is lacking in both credibility and sufficient probative value to suggest the reasonable possibility of its truthfulness for the entire period of 23 April to 23 May. The Chamber has considered, however, that it is reasonably possible that Ngirabatware was outside of Rwanda at some point during this time frame. As for the third alibi period from 23 June to 3 July, the Chamber notes that the prosecution has not brought evidence to support any allegation pertaining to this time frame. As such, the Chamber has not considered it necessary to assess the reasonable possibility of this alibi. Provision of vehicle to Interahamwe. The prosecution alleges that towards the end of April 1994, Ngirabatware provided Interahamwe with his vehicle, thereby facilitating their movement to massacre sites. In support of this allegation, the prosecution refers to the evidence of 3 prosecution witnesses. Having reviewed their evidence, the Chamber considers it clear that these witnesses provided no testimony that is capable of sustaining this allegation. The prosecution has not met its burden in relation to this charge. Distribution of weapons mid-May 1994. According to the prosecution, Ngirabatware and others used 2 Benz lorries and a Toyota pickup truck to bring arms and ammunition to Gisenyi Prefecture in mid-May 1994. The Chamber has identified no evidence in the record that could substantiate this allegation, nor has the prosecution referred to any. This allegation has not been proven. Bruxelles roadblock. The prosecution also alleges that in late May 1994, Ngirabatware distributed rifles at the Bruxelles roadblock and told the Interahamwe there to kill Tutsis. The prosecution, however, refers to no evidence that supports this allegation. One prosecution witness testified to having seen Ngirabatware about 1 month after President Habyarimana's death in Bruxelles area. This witness said that she saw Ngirabatware standing near the road with a group of people who were not doing anything unusual. This is insufficient to substantiate the prosecution allegation. Extermination. The Chamber observes that it has made a number of findings beyond reasonable doubt. None of these events, however, were pleaded in support of the charge of extermination as a crime against humanity. Verdict. For the reasons set out in the written judgment, having considered all the evidence and submission of the parties, the trial chamber finds unanimously in respect of Augustine Ngirabatware as follows. On count 1 of the indictment, conspiracy to commit genocide, the chamber notes that this has been withdrawn by the prosecution. On count 2 of the indictment, genocide, the chamber finds Augustine Ngirabatware guilty for instigating, aiding and abetting the attacks and killings of Tutsis in Namunyumba commune through his words and action in distributing weapons on 7 April 1994. On count 3 of the indictment, complicity in genocide, the chamber dismisses the charge because it is pleaded as an alternative to genocide. On count 4 of the indictment, direct and public incitement to commit genocide, the chamber finds Augustine Ngirabatware guilty for statements inciting the killing of Tutsis at the Chanika roadblock in February 1994. On count 5 of the indictment, extermination as a crime against humanity, the chamber finds Ngirabatware not guilty. On count 6 of the indictment, rape as a crime against humanity, the chamber finds Augustine Ngirabatware guilty for committing, through a joint criminal enterprise, in the extended form, the repeated rape of the Tutsi woman identified in paragraph 63 of the indictment. In considering the sentencing, In considering sentencing, the Chamber has taken into account the individual, aggravating, and mitigating circumstances of Augustine Ngirabatware. The Chamber also recalls that the gravity of the offenses is the deciding factor in the determination of the sentence. These have been fully detailed in the written judgment. The Chamber has the discretion to impose a single sentence and chooses to do so. Could the accused rise? The Chamber now invites Augustine Ngirabatware to stand up while his sentence is pronounced. Augustine Ngirabatware, the Chamber has found you guilty of genocide, direct and public incitement to commit genocide, and rape as a crime against humanity. For these crimes, and considering all the relevant circumstances, the Chamber sentences you to 35 years imprisonment. 35 years imprisonment. Augustine Ngirabatware shall receive credit for the time saved since his arrest on 17 September 2007 and shall be kept in detention under the present condition until his transfer to his designated place of imprisonment. Conclusion. This has been the summary of the judgment and sentence, and the trial proceedings in this case have now come to a close. The Chamber thanks all those involved in this case, and the proceedings end here. We so decided.
All rise.